Hello, everyone. My name is Teresa Rickard, and on behalf of all of us here at Jones and Roth, I want to welcome you to today's healthcare webinar. We're talking today about 2023 employment law updates, and we have the privilege of hearing from attorney Jaclyn Rudebeck today. She is from the firm Watkinson Laird Rubenstein, and she's going to walk us through a number of updates. We have a full agenda. We'll start with paid leave Oregon updates and then move on to employment practices, liability coverage, NLRA, and other recent state and federal updates. We're going to pause for Q&A after discussing paid leave Oregon, and then we'll have another Q&A session at the end. So really want to encourage you to submit your questions in the questions area of the GoToWebinar menu. And I also want to mention that a PDF of today's slides are available for you to download in the handouts area. Well, okay, so before we get started, I'd like to just quickly introduce you to our firm, our healthcare practice advisory team here at Jones and Roth. Our team provides a practice success plan, service plan that provides year-round value to practice owners and administrators, helping them to maximize their operational and financial performance. We also support the personal success of practice owners with integrated tax, retirement, financial management planning. We couldn't do these webinars without the support of Watkinson Laird Rubenstein. They sponsor our year-round webinar series, and they provide a broad range of legal services for healthcare practices. With expert knowledge of the complex regulatory environment, their healthcare attorneys help navigate those challenges of operating a healthcare practice. So let's get started. I'm really pleased to introduce our speaker today. If any of you know Jaclyn, she is an incredible and experienced employment and business attorney at Watkinson Laird Rubenstein. And she has been working with healthcare practices since 2007. In addition to experience as outside counsel, she's also held internal executive roles in the nonprofit and private sectors. She can really relate to the demands that her clients face. She also has advanced training in change management and organizational wellness, and her experience in these areas really allow her to offer support beyond just legal compliance, helping organizations truly thrive. Jaclyn, thank you for joining us today. We're excited to hear from you.
Thank you so much, Teresa.
Yeah.
I wanted to add, and everyone, you can hear me, right? Okay.
Yes.
Okay, good. I wanted to add, I saw the Jones and Roth team slide that you put together, and it occurred to me that I should have added to our slide that our firm is really proud to be the Registered Guard 2023 Reader's Choice Law Firm of the Year. And also even prouder, I would say, that we earned the honor of being one of the best places to work in Oregon from Oregon Business Magazine. So, you know, as I'm talking to all of you today, I'm wearing a number of hats because in addition to being an attorney that advises a wide variety of businesses, including a lot of healthcare practices, I'm also a business owner and I'm part of our firm's executive team. And so I'm navigating a lot of the same employment laws that I'm helping my clients to navigate. So it wouldn't be an attorney presentation if we didn't start with a disclaimer, right? So I want to be really clear that the information that I'm sharing today is general information about our state laws here in the state of Oregon. We're going to talk about a little bit of federal law, but our talking about these general laws is not intended as specific legal advice for anybody on this call. All of you should consult your own attorneys that you work with, whether it's my firm or a different firm, to determine which of these laws apply to your organization and how you're going to comply with them. So all of your specific analysis for how this stuff applies to your practice, your business, and how you're going to navigate it needs to be worked through with your counsel. So your participation here today does not create an attorney-client relationship between the folks on this call and me or my firm. And remember that the questions and comments that you ask today, which I encourage, definitely helps when we have participation. But anything that you share in the question and answer panel is not privileged or confidential. Okay, so today we are going to talk about Paid Leave Oregon, and we're going to spend about the first half of our time together today talking about that. Some of that will be review for those of you who participated in this webinar last year. But because the program is now live, we're going to talk about how it's going so far and things that we've learned and things that have changed since the last time we did one of these. And then we're going to shift gears. In the second half of our time today, I'm going to cover kind of a grab bag of different topics. We're going to talk about employment practices liability coverage, what that is, and whether you need it. We're going to talk about the NLRA, which stands for the National Labor Relations Act, and how that applies to non-unionized workplaces. And then we're going to talk about some other recent state and federal employment law updates. And as we go through all of these topics, we're going to encourage you to put questions into the questions panel. And then when we get to our Q&A segments, then Teresa's going to help by reading those questions to me so that we can really tailor this education to your questions and hopefully answer at least a few of them. Okay, but before we get started, even though I'm not in a room with all of you, it's really helpful for us to get a sense of who's on the call today. So I'm going to launch a couple of polls so that we can answer that question. So the first one is going to be, folks on the call today, what is your role within your organization? Are you an owner of the practice? Are you kind of the person with the privilege of handling HR and administrative responsibilities, or maybe you fall into another category? All right, we're getting lots of responses coming in. Okay, I'm gonna give it just another second. We'll close that poll and move on to the next. Okay. All right, we'll give it 1, 2, 3 more seconds, and I'm going to close that poll. So looks like we've got just about half of the folks on the call are practice administrators / HR folks. And then we have about an equal split between owners and other category. All right, next question is, and this is going to be important for a couple of things that we talk about today. There are a lot of different breakdowns in Oregon in particular about how many employees an organization has and which employment laws apply based on that headcount. But today we're going to focus on one key distinction, which is do you have less than 25 employees or do you have more, 25 and over? You all are on it. You're responding so quickly. I appreciate that. All right, we'll give it just another second or two, get those responses in. Okay, and I'm gonna go ahead and close that poll. So we have a little more heavily weighted, less than 25 employees. And then 38% of you are over 25 employees. That's really helpful information to have. Okay, last question. Because we're going to shift gears and talk about Paid Leave Oregon first, I'm curious, now that this program is live, how is your organization complying? How are you providing Paid Leave Oregon benefits to your employees? Are you going through the state program? Are you doing an equivalent plan? Or are you not sure? I'm going to launch that poll. And it is okay if you're not sure, particularly depending on your role within your organization. That's an okay thing to share. Okay, we'll give it just another second here. And I'm going to go ahead and close this poll. So we have over half of you are on the state plan, which is the default. We have a few folks on an equivalent plan. And then about a third of you are not sure. And that's more on that in a minute. All right, so thank you all for responding to the polls, for humoring me and sharing information. Okay, so with that, we're gonna start talking about paid leave Oregon. And again, some of this is gonna be a review, but just in case some of you are hearing this for the first time, I'm gonna talk just about the basic structure of the program. So paid leave Oregon is really kind of two main things. It's protected leave for employees, and it's insurance. So it's income replacement for employees experiencing particular life events. So that protected leave can be taken for one of three primary purposes. That's medical leave, family leave, and safe leave. We'll talk a little bit more about what those things mean. And our employees utilize those insurance benefits by filing claims for benefits, and those claims are paid through the Paid Leave Oregon program. Now, we just found out for most of you on this call, you are utilizing the default state plan. And so that means that our employees are actually filing those claims to the state, and the state is processing them and paying out benefits if the claim is accepted. This program, as a reminder, it applies to all Oregon employers. So anyone who has one or more W-2 employees in Oregon, this program is going to apply. And it applies to any Oregon employee who has earned at least $1,000 in wages in the previous year. So pretty quickly, anybody who's earning W-2 wages is going to qualify for participation in this program. Other folks can opt in. So if we have independent contractors, if there's a sole proprietorship, those categories of folks can participate in the program, but it's not mandatory. But for everybody else, it's mandatory to participate. All right, so we're going to talk about the reasons that an employee can take leave under this program. Employees can take leave for their own serious health condition, or they can take leave for a family member's serious health condition. And serious health condition under this law is actually serious. So this is a health condition that is requiring a prolonged course of treatment. It's something that is providing or requiring inpatient care, resulting in incapacity for the employee. This is not, I'm out of work for a couple of days because I have the flu. That's not generally, unless someone is debilitated by the flu, generally that's not going to qualify for Paid Leave Oregon. This is serious stuff. Family leave is caring for a family member with a serious health condition. Again, we're defining serious health condition the same way. Or it's time that an employee is taking off work to bond with a child during the first year after that child's birth, or adoption or foster placement into the family. And then safe leave is it's time off of work to obtain assistance, including legal assistance, medical assistance, working with law enforcement, if the employee is a victim of domestic violence, harassment, sexual assault, or stalking. So that's our safe leave definition. Importantly, this new Paid Leave Oregon benefit program doesn't cover absences related to sick child leave, which if your business has over 25 employees and you are subject to the Oregon Family Leave Act, which is a different law, but related. We're going to talk a lot more about the overlap between the two. That law covers absences from work for other purposes, including sick child leave, bereavement leave, and military family member leave. This Paid Leave Oregon program doesn't cover time off of work for those purposes. Okay. Included a screenshot of this. This is not a chart that my firm prepared. This is a portion of a resource that's available on the Paid Leave Oregon website. And I would encourage everybody on this call, if you have any responsibility for complying with employment laws and all of these various leave laws in the state of Oregon, to get very familiar with the resources available on the Paid Leave Oregon website if you haven't already. This chart, I think, is a particularly helpful illustration of the different programs that we have that an employer might need to comply with. This is, as I said, it's just an excerpt of the chart. It's actually really long if you scroll down to the whole thing. But this is a nice side-by-side comparison of what qualifying leave purposes fall under each of these various laws. So remember, we have Paid Leave Oregon, which is our newest law in the state of Oregon that provides protected leave from work for employees. We have OFLA, that's the Oregon Family Leave Act, which applies to employers with 25 or more employees. That law has been on the books for years. And importantly, when Paid Leave Oregon was enacted, OFLA didn't go away. OFLA still exists. And as I said, it provides a lot of similar benefits. A lot of the time, Paid Leave Oregon and OFLA are going to overlap, but not always. So what this chart shows us is in the green, the areas where they do overlap. The gray is the areas where they do not. And what I'm working with my clients really closely on right now is navigating, in particular, those areas where the programs don't overlap, where they're not the same. Then we have PFMLI, which is our Federal Family Medical Leave Act. That applies to larger employers with 50 or more employees. So some of you on this call might be subject to PFMLI in addition to OFLA. Many of you likely are not based on the answers to the poll question. But OFLA and PFMLI are really similar laws, but again, they don't completely match up in terms of the protections that they require employers to provide. OFLA is more expansive than PFMLI. And then we have our Oregon sick leave law, which also has been on the books for a long time and also did not go away when this new Paid Leave Oregon Act was enacted. So for Oregon employers now, we have Paid Leave Oregon, we have the Oregon Family Leave Act, and we have Oregon sick leave. Very confusingly similarly named laws, all providing slightly different protections and benefits to our employees. So it's a really challenging landscape for us to navigate and keep track of, in particular, the areas where they don't overlap. So what we need to keep in mind now is when an employee has time off of work that is covered by one or more of these laws, one of our responsibilities as an employer is to keep track of how much of this protected leave have they used, how much do they still have available. And what we can see by looking at this chart is there are going to be times, I tend to think of our banks of leave as like a bucket, okay? So think about it like we have 4 buckets, or 3 if you're not subject to PFMLI. And sometimes an employee is going to take leave that's protected and covered by all of these laws. So when that's the case, we're draining all of those buckets concurrently. We're draining them simultaneously. We're subtracting the amount of leave available from every bucket at the same time. But what we can see here is that sometimes we might be draining one of the buckets, but not the others, because there's leave available under one law's purposes, but not under the others. So that's where I can help and where employment lawyers come in, is helping our clients figure out, first of all, if an employee is taking leave, what laws apply, and are we tracking this leave under Paid Leave Oregon, OFLA, and Oregon Sick Leave, or just under one or two of those laws? Figuring out how much leave have they used, how much do they still have available to them. Clear as mud? Okay. Moving on from there. So the amount of protected leave under Paid Leave Oregon is generally 12 weeks, which is the same amount of protected leave that is available most of the time under OFLA. Paid Leave Oregon also provides an additional possible 2 weeks for certain pregnancy-related conditions, so 14 weeks total. Importantly, as an employer, you have to continue the employee's health insurance while they're on leave, and the employee can't be required to pay any more than their regular share of the premium. So if an employee typically pays, if the employer pays 50% and the employee pays 50%, you can require the employee to continue paying their share while they're on leave, but you can't require more than that. And if they're not able to pay it during the leave, you can't let it lapse. You're required to make sure that their health insurance remains in place while they're on that leave. If you pay the employee's share of the premium while they're on leave, either because they can't or just from a practical perspective, normally that comes out of payroll deduction. If they're not earning wages from you during that time, you can't deduct from their paycheck. So you might front their premium during that period of time. You can recoup that later via payroll deduction, but that recouping is capped at 10% of their gross wages. And then your other primary responsibility, if you have an employee that utilizes paid leave benefits and makes a claim through the program, is reinstatement. So most of the time, if you've got an employee that has worked for you for more than 90 days, you're going to need to reinstate that employee to their same position when their leave ends. So that's an important thing to keep in mind. 12 weeks is a pretty long time, particularly in a small organization. If you have someone out for 12 weeks, you're probably going to need to try to backfill to some degree if they're out for that whole period of time. But just keep in mind that you are required to reinstate them when their leave has expired, when they've used the whole allotment and they're ready to come back to work. Okay. If their position was eliminated during that period of time, and we mean truly eliminated, not just filled by somebody else, if you're an employer over 25 employees, you're going to need to reinstate them to any available equivalent position for which they're qualified. So re-employ them in a different job. Okay, we're going to move pretty quickly through the next couple of slides because I have a lot of material to get through. Employer size, how do we figure out if we're at 25 or, if we're a large employer or a small employer? We're going to look at our employee census on the 12th of each month for the last year, and we're going to take the average of that. So we're going to look at the 12th of the month and look at that for the entire year and figure that out. And our size is determined just once for the whole year. So if you're an employer that really kind of dances right on that line, once you've determined your employer size for that year, it's fixed for the whole calendar year. One of the main distinctions for small employers with less than 25 employees is they're not required to pay in the employer share into this program. So the way that the program is funded in the default state program is employees pay in 60% as a payroll tax, and larger employers over 25 pay in 40%. Smaller employers are not required to pay into the program. And our rate for this year, as I said, it's the employee pays 60%, the larger employers pay 40%, and that's on 1% of wages up to $132,000 per employee. It's one rate for the whole state. Every employer on the state plan in Oregon pays the same rate. It's not dependent on claims history. And we're coming up on a key timeline here because this year that we're in right now, 2023, was the first year of implementation of this program. In next month, November 15th is the deadline for the employment department to announce what the state rate is going to be for next year and whether it's going to be a change from this year. So we're all watching eagerly to see what that rate is going to be set at for 2024. And then the benefits, similarly, are based on a fixed statewide calculation of the average weekly wage. And there's a lot of numbers on these slides. The slide deck is available to you, so I'm not going to go into this in detail, but I think the salient thing to keep in mind here is that for some portion of our employees, their income replacement, their benefits available through the program is 100% of their employees' pay. For our higher earning employees, the benefits are capped at 120% of the average weekly wage, which for this year is just over $1,200. That's the average weekly wage, which works out to just over $63,000 a year. I think in terms of annual salaries, it's just how my brain works. So those are helpful numbers to keep in mind. PTO, we're going to talk about this more in a little bit, but employees can use their employer-provided PTO if your policies allow that, but as an employer, we can't mandate that they do that. Similarly, we can't mandate that our employees file paid leave Oregon claims. It is up to them as to whether they choose to make a claim for benefits under this program. And then equivalent plans. So we heard from a significant percentage of the folks on this call that some of you have chosen to participate in this program via an equivalent plan. So we've purchased insurance from a private insurance carrier that is at least as generous as the state plan. It can't cost our employees any more. It covers all of our employers. And that was a decision that businesses over 25 employees, most of them, considered about this time last year. So many employers over 25 employees chose to go with an equivalent plan because a lot of the insurance carriers made that a very attractive option. They, rather than having to pay in effective January 1, a lot of carriers quoted premiums not starting until September, which is when employees could start filing claims for benefits. A lot of the premiums quoted were a little bit lower than the rate that employers would have been paying through the state plan. So at least in this first year, for a larger employer, the equivalent plan option was a pretty attractive one. I think we will see as of November 15th, when the new rates are announced, and when our carriers start to quote what their rates for 2024 are going to be, whether that maintains, whether that remains the case. But the key distinction, a key distinction, is if an employer is participating through an equivalent plan, their employees make a claim to that insurance company for paid leave Oregon benefits rather than filing it with the state. That's the difference. The insurance company is administering it rather than the state administering the program. There are some employers that are fully self-insured for this and totally self-administering it, but frankly, I'm not seeing very much of that with our client base. Most are either on the state plan or on an insurance company equivalent plan. Okay, penalties for non-compliance. Real quickly, 1% of annual payroll if you fail to file your reports or make your contributions on time. If you fail to return an employee to their position as required by the law, they can sue for reinstatement and get back pay. If you're failing to post the notice and comply in other ways, that's going to be an unlawful employment practice in Oregon, and there are fines associated with that. That's why we care. All right, so far, what are we seeing? So as of October 6th, when claims had been live, they opened up the process for filing claims in the middle of August. Employees could begin taking leave effective September 3rd. And in basically that first month, the Oregon Employment Department, these are just the state numbers, not equivalent plans, had already received 22,000 claims. with, I think this is a typo on this slide, and if it is, I apologize. I think it's 2.1 million in benefits paid. I don't think it's 21 million, but I will go back and verify that information. Already, we have seen some legislative fixes that I want to spend just a couple of minutes on. Remember, Paid Leave Oregon and OFLA are really similar laws. They overlap in a lot of ways, but there were some problematic discrepancies between those two laws that were going to make administration even more tricky than it's still going to be. We didn't fix everything here, but one of the changes that the Oregon legislature made is to make the definition of a family member the same between the Oregon Family Leave Act and Paid Leave Oregon. What the result of that was that it expanded the definition of a family member for OFLA. So who's a family member now? Family member, effective September 3rd, is your spouse or domestic partner, your child or your child's spouse or domestic partner, your parent, or the parent of your spouse or domestic partner, siblings or step siblings, grandparents or your spouse's or partner's grandparents, grandchildren. And then here's where it gets real interesting. Paid Leave Oregon added any individual related by blood or affinity whose close association with a covered individual is the equivalent of a family relationship. So BOLI added some temporary rules defining what does affinity mean? What kind of factors are we looking at to figure out if this person isn't related by blood, how are we evaluating whether they're going to be considered a family member or not? So we're going to look for things like shared financial responsibility. Are we on a lease together? Are we both on the same bills, accounts, utilities, things like that? Do we own property together? Is this person your emergency contact on file with your employer? Or elsewhere? Is there a history of one of you providing care for the other? Is there a history of cohabitation? For how long? For what purpose? Geographic proximity, we're going to look at that. And then kind of other factors. They left the window open for other factors demonstrating a close family-like relationship. So this is something new for employers to think about, that, someone comes to you, an employee makes a claim and says, hey, I need this protected time off because this person, who's not a family member, but is a very close person in my life, is having surgery or undergoing cancer treatment or something, and I'm providing care for them. That this is a situation where, again, this is new territory for employers, that those folks might be considered family members by affinity, and that we might be looking at covered protected leave for that care that's being provided. One of the other legislative fixes is initially the rules regarding PTO, so employer provided PTO. When can an employee use that when they're also making a claim for Paid Leave Oregon benefits? Initially, the rules were an employee could only use their employer provided PTO if they weren't getting 100% income replacement under the law to make up the difference, to kind of top off so that they were making their full wages. The legislature did away with that. And so now employees can apply for PTO and make a claim for Paid Leave Oregon benefits. I actually think this is probably a good thing, because administratively, I think it was going to be a nightmare for employers to have to process, I've been told that my employee is filing a claim for Paid Leave Oregon. I'm not in control of how quickly a decision is made on that claim, and I'm not in control of the amount of benefits that are getting paid to that employee. And I'm trying to process payroll, and they're putting in for PTO, and otherwise, as the rules were originally written, the employer would have to either wait to determine whether the employee could use PTO, and if so, how much, and then maybe have to cash it up or reconcile it in future pay periods. So that obligation has gone away now, and now employees can use their PTO. The risk to the employee, if they choose to kind of double dip out of both options, is that they won't have their PTO available for use later, but it's their choice. whether they use either or both programs basically now. The other thing that Paid Leave Oregon and OFLA weren't in sync about, and now they are, is how do we determine a leave year? So if we're talking about an employee, in most cases, being eligible for 12 weeks of leave over the course of a year, what is a year and how is that determined? Paid Leave Oregon laws count it rolling forward from the first day that an employee takes leave. And now that's the only way that you can count it for determining OFLA leave as well. Used to be you could look at OFLA rolling backwards or on a calendar year. These other ways of counting have gone away now. So if you are an employer that is subject to OFLA, if you're over 25, you need to look at your OFLA policy and look at whether you need to amend it to correct the leave year definition in your policy. If you are also subject to PFMLI, so if you have more than 50 employees, you've got to give your employees 60 days notice of that change. So that's an action item for folks. And I think one of the interesting things that we're navigating so far and in conversation with the employment department about is the situations where Paid Leave Oregon and OFLA overlap. They're supposed to run concurrently, but I think there are a lot of questions now about how that's really going to be administered. So first of all, nobody can force an employee to file for Paid Leave Oregon. So they could take their OFLA leave and then decide to file a claim for Paid Leave Oregon. And the question is, how is the state going to enforce this 16-week maximum amount of leave across the two programs? We don't know yet. We're waiting to see how that's going to play out. Okay. If you're not already, you should get familiar with Francis Online, which is the employer and employee portal. And I'm going to skip through the next couple of slides just in the interest of time, but these are just some of the tools and calculators that are online. All right, so as a reminder, you want to make sure that your notice is posted. So there's as with everything, there's a poster about this, and we've got to make sure that that notice is posted and that we're giving that information to employees. Importantly, for those of you that have an equivalent plan, make sure your employees know that and make sure they know that if they're making a claim for Paid Leave Oregon, they need to make it to the insurance company and not to the state. There's definitely been some confusion there with employees that are insured under an equivalent plan, filing claims with the state. So make sure they know. If you're one of the folks that in the poll that we took earlier said, I don't actually know how my organization is doing this, find out because that's going to be important. Okay. And then, of course, we want to check in and make sure that our payroll provider, whether we're doing payroll in-house or whether we outsource that we're correctly processing these new deductions. We're responding to claims if the insurance company or the state of Oregon is requesting verification from the employer. You want to make sure you're responding to those. We're already seeing some fraudulent claims being filed, so be vigilant to make sure that you're looking at any request for information that comes through. And you want to make sure that you're updating your employee handbooks to add language about Paid Leave Oregon, what it is, what it isn't. And then if you're an OFLA subject employer, you want to update that plan. Okay, questions about Paid Leave Oregon? Teresa.
Yes, we have a question that may or may not have been addressed in your recent explanation. I'll ask anyway.
Okay.
One person has been told by Paid Leave Oregon that an employee could choose to go on OFLA and not use PLO, even though the reason is qualifying, resulting in them being able to take additional leave under PLO later in the year. Is that true in your understanding?
That's a great question, and it kind of is true, especially right now. So because we're in this first year of the Paid Leave Oregon program, remember, Paid Leave Oregon claims didn't begin until September 3rd of this year. So if an employee took any OFLA protected leave prior to September 3rd, that didn't do anything to reduce the amount of paid leave Oregon benefits and time off that that employee had available. So that's something that's somewhat unique to this first year. But the real question is, going forward in, for once 2024 begins, paid leave Oregon and OFLA are available to all employees. Actually, as of September 3rd, those are available to all employees of employers over 25. And the question is, since no one can mandate that an employee files a claim for PLO, if they don't do that, but they take leave that is covered by OFLA, so they're taking leave for a qualified purpose, it's reducing their amount of leave available under the Oregon Family Leave Act. They haven't initiated a PLO claim. For how long does their 12 weeks of PLO remain untouched, even though they've taken OFLA? And how is the state going to navigate that? And the answer is we don't really know, but we are hearing from multiple individuals at the employment department that they don't really have jurisdiction until an employee files a PLO claim. So that's not a real hard and solid answer, and that's because we don't quite have one yet, but it is certainly possible that an employee could not choose to file a claim for PLO and kind of keep that whole bucket of benefits untouched.
Great. Okay, how about, do you have any recommendations or examples on how to put all of this jargon in your employee handbook?
I sure do. So our firm, and I'm sure every firm that does employment law in the state of Oregon, we have policies that we've been drafting for our employer clients and have been since last fall putting that policy language in handbooks to try to explain to employees what this is, how it's administered, and as I said, what it's not, and the employer's role in this. But yes, I mean, I unfortunately can't kind of spit one out for you because it's really going to depend on your specific organization. It's also going to depend on what types of PTO or vacation sick leave benefits you already provide, but definitely work with your employment counsel on that.
Great. How about PLO reinstatement? Do you have to offer same shift, like days of the week or hours in the day, or just the same position and pay?
Yeah, that's a great question. And, I'll be honest and say off the top of my head, I don't remember if the regulations actually require same shift in terms of like hours and days of the week. But one of the examples, actually the example that I had in my slide is like if someone was in a delivery driver job, they need to be returned back to the same route. And so I think that the regulations are pretty specific on that it needs to be as equivalent as possible. And if that job, if that shift still exists, that's what in most cases our employee is going to need to be returned to. But that is a really fact specific question that you're going to need to work with your employment attorney on to make sure that you are complying with that requirement of the law, because it's going to vary situation by situation.
Okay, great. Let's see, how many times can an employee file for paid leave Oregon? Is it only 12 weeks in a calendar year, 12 weeks over a lifetime?
Right, so their available leave is 12 weeks per year, and that 12-month counting is rolling forward from the date that they first take leave. So it resets basically. And it can be taken in single day increments. So for example, if someone has dialysis every other Friday and they need to take protected time for that, they would file a claim for every single day that they're taking leave because it's not continuous. It's intermittent, it's not continuous.
Great. What if you offer an employee an equivalent position and they turn it down? Can they file for unemployment?
Good question. It depends. That's a classic lawyer answer. Possibly they could. But most of the time, if an employee is offered a position and they decline it, that usually often will be a disqualifying event for unemployment purposes.
Okay, touching back, I believe, on the handbook question, are there examples that could be provided for our attendees that they could review and then see how that fits with their specific organization or accrual policies? Or, you know, what comes to my mind is Cascade
Yeah.
Employers Association is a great resource. I don't know if you have any other resources to
Yeah,
share.
Cascade provides a lot of good resources, and
Mhm.
yeah, so I would echo that. The other thing that I would look at is the PFMLI Oregon website has a lot of great
Mhm.
employer tools and language that, again, they're not going to be specifically tailored for your individual organization, but there's a lot to build from there. So I would look there, and then I would talk with your employment attorney about it.
Okay, great. All right, we'll let you continue on.
Okay, we're going to move on. I'm going to go real quickly through the rest of this because this time is evaporated. Um, okay, so I'm going to talk about employment practices liability coverage. This is insurance that our businesses can carry that specifically covers situations where we are getting sued. There's some sort of claim that's brought against the organization related to an unlawful employment practice, some other, wage claims, discrimination claims, harassment claims, things like that. So the question, first of all, is do we need it? We recommend this to all of our clients. And just as some examples, employment cases when they are litigated or, if a claim is filed with BOLI and you try to go through a settlement process, they can get expensive really quickly. And so we definitely recommend that our employers carry coverage for these types of claims. They are one of the most common types of risks of exposure that employers face. And so we strongly recommend having it. Then the next question is, how much coverage should we have? And that's going to be something that you're going to need to work out with your insurance carrier and certainly within your organization's ability to pay the premiums. But things that you want to consider are, how many employees do you have? Do you have different locations? What is the wage range of your employee base? And the reason that's relevant is a lot of the damages that we see in employment cases are based on things like back pay and, or front pay, which is I'm losing my wages going forward. So if you have higher wages, then you're going to need more insurance because the benefits or the damages rather that might be assessed against the business are directly tied to the amount of wages the employee made in a lot of these types of cases. If you have coverage in place, you're also going to want to understand what are the coverage limits, if any, with respect to not just protecting the business and covering the business, but individual managers within the business. We'll talk more in a little bit about why that's important. But the takeaway here is absolutely look at having employment practices liability coverage in place. A lot of clients would have somewhere between $250 and $5,000 or $500,000 worth of coverage. Given the types of verdicts that we're seeing in litigated court cases in Oregon, which the average in 2022 was $1.2 million in verdict. EEOC enforcement has increased substantially, and those settlements, and as I have on the slide, range in the high 5 figures to mid 6 figures. So that's relevant data in figuring out how much coverage do we need. Okay, now I'm going to talk about the National Labor Relations Act and does it apply to my workplace? And the answer is yes. If you have employees, even if they are not unionized, there are some sections of the National Labor Relations Act, which is a federal law, that are going to apply. And the theory behind this, or the reasoning behind it, is Yes, most of the National Labor Relations Act is focusing on unionized workplaces, but how did they get unionized in the first place? There are certain employee actions, and in particular, employee communications among each other that are protected under this federal law. It's called concerted activity. And concerted activity is really a way to talk about employees communicating with each other about their working conditions and their wages. Those are the important elements. They've got to be communicating with their coworkers, and it's got to be talking about their working conditions and their wages. So what does that mean? It means that, first of all, you cannot prohibit your employees from talking about their compensation with each other. Don't do it. It's really risky. It's illegal under federal law. The other thing that's really important to note right now is, first of all, that there's been an increase in National Labor Relations Board, which is the federal entity that has oversight over enforcing the National Labor Relations Act. So that entity has increased its enforcement over recent years and during this administration. There have also been a number of opinions that have come out in National Labor Relations Board cases that are relevant to all employers, even non-unionized workplaces. One of those really important opinions relates to severance agreements. So if we have an employee that we're parting ways with and we offer them a severance agreement, usually some severance pay goes along with that. There are certain terms that used to be pretty standard in those severance agreements, like non-disparagement, non-disclosure, that are no longer allowed. And even presenting an employee with a severance agreement that contains those terms is now an unlawful employment practice. So if you have a template severance agreement that you've been using for years, you need your attorney, you need your employment attorney to look at that agreement and make sure it's still okay to use. We also, I'm looking for the record button. Teresa had sent me a message and I am showing that it is recording. So I don't know if we need to hit stop or something. Sorry, Teresa, I don't know how to do that. Okay, we're gonna keep going.
Okay,
Sorry,
I'll jump in and help take care of that. You can continue. Thanks, Jaclyn.
Okay. The other thing that we need to keep in mind is social media policies that prohibit certain conduct or posting on social media in ways that are disparaging to the employer. We want to be really careful about the language that we're using there. So definitely check with your employment attorney about that and about other policies that could be interpreted to kind of chill the employee's exercise of those Section 7 rights. And in the interest of time, I'm going to move on from that. Okay, just a couple of quick reminders that our Oregon pay equity laws, which again have been on the books for several years now, this isn't new this year. We want to be very intentional and have a system for how we're setting our compensation within our organization. We can't ask about or consider our employees' prior salary history when we're looking at making a hire. And for a period of time, hiring and retention bonuses were excluded from the definition of compensation under our pay equity laws, but that sunset a year ago. So we need to make sure that we're including any hiring and retention bonuses and that we're considering those as part of an employee's compensation for our pay equity analysis. If you don't know what a pay equity analysis is, ask your employment attorney because you need to be paying attention to this. Okay. Couple other things, a reminder that the Oregon Workplace Fairness Act requires us to have our harassment discrimination prevention policy available to all employees in the workplace. And we have to provide a copy of it anytime an employee makes a complaint, or if they bring a complaint and then they're signing a release of that claim, we need to provide it again. We also need to provide a pregnancy policy or pregnancy accommodation notice within 10 days anytime an employee notifies us of their pregnancy. Talk to your employment attorney about that too. We've got a new I-9 form that must be in use by October 31st. So next week, if you're not already using it, make sure you can just Google new I-9 form and you'll get to the right form. Make sure that you're using that updated I-9. If you have any employees requesting religious accommodation, we had a US Supreme Court opinion this year that changed the definition of what is an undue hardship for an employer to justify denying that accommodation. Make sure you're talking to your employment attorney about that as well. This is kind of a interesting, probably less significant one, but just a reminder that we have a new law in Oregon that effective this September, if you have a TV in a public area like a waiting room, you have to use closed captioning on that television, and our employees are required to be trained on that, and they need to know that that televisions have to have closed captioning on if they're in a public space. Okay, so I want to really quickly talk about just a reminder that our Oregon employment discrimination laws, in addition to business entities being liable, the law says that any person that aids or abets discriminatory conduct or unlawful employment practices by the business can also be individually liable in those cases. That's not new, but there is a new Oregon Court of Appeals case that interpreted that law and solidified that. So managers, possibly members of an LLC, if they're involved in the management of the business, in addition to the business getting sued, these individuals can be named, appropriately named, in the lawsuit if they were aiding or abetting the business's discriminatory or unlawful conduct. So when you're talking about having employment practices liability coverage, you need to be asking who's covered under this policy, and will it defend not just the business entity, but also members of management that are involved in the decision. Okay, last couple notes here, and then maybe we'll have a minute or two for questions. I want to call out that in Oregon this year, our OSHA civil penalties increased massively. For non-serious violations, the minimum penalty used to be $50, and now it's $1,116. That's the minimum non-serious violation fine, civil penalty under Oregon OSHA. Maximum for a non-serious violation is 15 grand. And for serious, willful, or repeated violations, we're looking at penalties from $50,000 to $250,000 per violation. OSHA means business, y'all. They are serious about fines for non-compliance. As a reminder, though, Oregon's OSHA, in addition to their enforcement arm, they also have an employer advising service. And there's a firewall in between those things. So if you as an employer reach out to OSHA's employer support and ask for support, ask for a consult, ask for them to come on site and do a walkthrough with you, help you comply with their policies, that's not going to put you on their radar and subject you possibly to fines. In fact, it might do the opposite. It might demonstrate, hey, we're trying to comply. Keep in mind as well that there's a presumption that an employee terminated within 60 days of reporting an OSHA possible violation, there's a presumption that was done in retaliation, and liability increases from there. Okay, I think I really rushed through all of that stuff at the end, so I apologize. There's a lot to get through, and I typically am overly ambitious in how much can be covered in one of these hours. Any final questions, Teresa, before we wrap it up?
No problem. You did great. We did have a really quick follow-up back to the paid leave Oregon topic. Someone's curious just about how the time is calculated, if it's per employee per year period or per employee per year per company. Like if they were to change jobs after using leave, does the clock sort of start over again with that new company?
That's a great question. And no, it does not start over. So this is one of the unique aspects of this being a state-run program for most employers, um, rather than an employer by employer specific program. So employee files a claim with the state, their available leave runs connected to the employee and not per employer. The real tricky thing is if an employee is with an employer that has an equivalent plan and then they leave that job and then they go to work for an employer that is insured under the state plan, administratively, how are we tracking all of that? And I think it's a little bit too soon to know how all of that's going to get navigated, but the intent is that the allotment of leave is per employee, not per
Okay.
employer per employee.
Okay, great. Thank you.
Good
Thank you.
question.
Thank you. Thank you so much for sharing your expertise with us today. And a big thank you to all of our attendees who joined us. We really do hope that you're walking away with a better understanding on some of these complex issues and found today's presentation helpful. Take care, everyone. Have a great weekend. We'll see you for our next webinar. Bye-bye.
Bye, thanks.